Welcome to the Law GH channel and welcome to part 2 of episode 13 on the law of tort. We are continuing with the final part on vicarious liability, that is the employer's duty to third parties. Today we are looking at the liability to third party. Before we begin, please do well to read the decision of Lord Denning in Stevenson and MacDonald. Let's begin by showing the tests used in distinguishing between employee and independent contractor. Test 1. Entrepreneurial test. In Market Investigations Limited and Ministry of Social Welfare, 3 critical questions were laid to help establish this test. Namely, A. Whose business is it? B. Is the party, that is the alleged employee, carrying on the business for himself or for a superior? C. Is the party taking a financial risk with a chance of loss as well as profit? And if A is the owner of a business and carries it out for himself and bears the losses or benefits from the profit, then A is an independent contractor and not an employer. The contract then is for services and not of service. Flowing from this, 2 questions were left unanswered, namely, where an employee of a master is loaned to another employer temporarily, who owes him the duty of care in the interim? 2. If a tractor is hired out with its driver, who owes a duty of care to the driver, the owner of the tractor or the one who has hired it? A solution is said to have been given from Mersey Docks and Harbour Board and Coggins and O'Reilly and Imperial Chemical Industries Limited, which is that where a workman is hired to another employer, that employer who would be vicariously liable for his torts is also the employer who owes him the duty of care. Test 2. The control test. In Ewins and Nowak's, Bramwell LJ explained who a servant is by saying, a servant is a person who is subject to the command of his master as to the manner in which he shall do his work. In Performing Rights Society Limited and Mitchell and Booker, McCarty J. explained this test as follows. It seems, however, reasonably clear that the final test, if there be a final test, and certainly the test to be generally applied, lies in the nature and degree of detailed control by the person alleged to be a servant. This circumstance is, of course, one only of several to be considered, but it is usually of vital importance. The point is put well in Pollock on Tort, 12th edition, page 79 and 80. The relation of master and servant exists only between persons of whom the one has the order and control of the work done by the other. Additionally, differentiating a master from an independent contractor, he said, a master is one who not only prescribes to the workman the end of his work, but directs or at any moment may direct the means also, or, as it has been put, retains the power of controlling the work. An independent contractor is one who undertakes to produce a given result, but so that in the actual execution of the work, he is not under the order or control of the person from whom he does it, and may use his own discretion in things not specified beforehand. The rule is stated in much the same way in Salmon's Law of Tort, 6th edition, page 96, where that able jurist says, a servant is an agent who works under the supervision and direction of his employer. An independent contractor is one who is his own master. And he illustrates his statement as follows. Thus, my coachman is my servant, and if by negligent driving he runs over someone in the street, I am responsible. But the cabman whom I engage for a particular journey is not my servant. He is not under my orders. He has made a contract with me. Not that he will obey my directions, but that he will drive me to a certain place. If an accident happens by his negligence, he is responsible and not I. See also Viscount Simon in Mercy Docks and Harbour Board and Cogents. Under this test, a quasi-employee is owed this duty by the employer as well. See Oliver J. in O'Reilly and Imperial Chemicals Industry Limited. Test 3. Integration Organization Test. In Stevenson, Jordan and Harrison Limited and McDonald and Evans, Lord Denning said, one feature which seems to run through the instances is that under a contract of service, a man is employed as part of the business, whereas under a contract for services, his work, although done for the business, is not integrated into it, but is only an accessory to it. In distinguishing between a servant and an independent contractor, Lord Thankirton stated that a contract of service existed where certain indicia were present, namely A. the master's power of selection of his servants, B. the payment of wages or other remuneration, C. the master's right to control the method of doing the work, and D. the master's right of suspension and dismissal. Test 4. The economic reality test or multiple test or pragmatic test. In Ready Mixed Concrete, Southeast Limited and Minister of Pensions and National Insurance, McKenna J. said, a man does not cease to run a business on his own account because he agrees to run it efficiently or to accept another's superintendence. He further outlined 3 conditions to be met for one to establish a contract of service, namely A. the servant agrees that, in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. B. He agrees expressly or impliedly that in the performance of that service, he will be subject to the other's control in a sufficient degree to make that other master. C. The other provisions of the contract are consistent with it being a contract of service. On the third condition, he then used 5 illustrations to explain what he meant by provisions inconsistent with the nature of a contract of service. And these are: 1. A contract obliges one party to build for the other, providing at his own expense the necessary plant and materials. This is not a contract of service, even though the builder may be obliged to use his own labor only and to accept a high degree of control. It is a building contract. It is not a contract to serve another for a wage, but a contract to produce a thing or a result for a price. 2. A contract obliges one party to carry another's goods, providing at his own expense everything needed for performance. This is not a contract of service, even though the carrier may be obliged to drive the vehicle himself and to accept the other's control over his performance. It is a contract of carriage. 3. A contract obliges a laborer to work for a builder, providing some simple tools and to accept the builder's control. Notwithstanding the obligation to provide the tools, the contract is one of service. That obligation is not inconsistent with the nature of a contract of service. It is not sufficiently important matter to affect the substance of a contract. 4. A contract obliges one party to work for the other, accepting his control and to provide his own transport. This is still a contract of service. The obligation to provide his own transport does not affect the substance. Transport in this example is incidental to the main purpose of the contract. Transport in the second example was the essential part of the performance. 5. The same instrument provides that one party shall work for the other subject to the other's control, and also that he shall sell him his land. The first part of the instrument is no less a contract of service because the second part imposes obligations of a different kind. Concluding on the difference between servant and independent contractor, he said, if the question is whether he is carrying on that business for himself or for another, it must be relevant to consider which of the two owns the asset, the ownership of the tools. and which bears the financial risk, the chance of profit, or the risk of loss. He who owns the assets and bears the risk is unlikely to be acting as an agent or a servant. If a man performing the service must provide the means of performance at his own expense and accepts payments by result, he will own the assets, bear the risk, and be to that extent unlike a servant. Let's now turn to examine the final part of this episode. To be able to paint the employer with liability, the following issues must also be established. Whether at the material time the person was an employee of X, whether the employee acted in the course of his employment. For these two issues, see Lord Salmon and Viscount Simon and Century Insurance Company Limited and Lothian Ireland Transport Board. See also Al Smith J. in Beard and London Omnibus Company. In this case, Roma CJ held that a bus conductor does not drive as part of the course of his employment. In the same case, Justice Vaughan also held that it would be unfortunate that it should go forth to the public that whenever a conductor is found exercising some function of the driver, no case can be made against the omnibus proprietor unless the plaintiff is in a position to call evidence to account for the temporary absence of the driver. It seems to be a sounder view that where a driver and a conductor are sent out in charge of an omnibus and complaint is made of some act done by the conductor, it should be left to the jury to say whether the act so complained of was within the authority given to the conductor. It is all very well to say that one knows that the authority given to a driver is to drive and that given to the conductor is to conduct, but it is incorrect to say that one is entitled to deal with the case on that hypothesis. Contrast the case of Ricketts and Tilling Limited, where Buckley LJ held that there was evidence of negligence on the part of the driver in allowing the omnibus to be negligently driven by the conductor. And also in Achijina and J, the Court of Appeal held that since the vehicle was owned by the appellant who employed the driver who drove the vehicle at the material time to cut sand and stone, a presumption was raised that the accident occurred at a time when the driver was driving in the course of his master's business, and the onus shifted onto the appellant to rebut this presumption, but he failed to do so. Let's now identify the test of liability. Traditionally, as could be seen from Salmon on Tort, first edition 1907, page 83, and Salmon and Houston on Tort, 21st edition 1996, page 443, there are two main tests of vicarious liability. A. Was the servant doing an act of a kind not authorized by the master, or is it just a wrongful performance of an authorized act? If the former, the master is not liable. If the latter, the master is liable. Another test is, was the servant acting within authorized limits of time? In Watman and Pearson, Keating J. said, it is always a question of degree whether there was such an amount of deviation by the defendant's servant from the line of his duty that he ceased to be acting in the course of the employment of his master. See also Biles J. in the same case. In Rayner and Mitchell, Lord Coleridge, C.J. stated that wherever the master entrusts a horse or carriage or anything which may readily be made an implement of mischief to his servant to be used by him in furtherance of his master's business or for the execution of his orders, the master will be responsible for the negligent management of the thing entrusted to the servant, so long as the latter is using it or dealing with it in the ordinary course of his employment. See also Zaglo and Kumasi Brewery Limited. The new position could be seen in Leicester and others and Hesley Hall Limited. Here the test laid by Lord Steen is that when determining whether an employer was vicariously liable for an employee's wrongful act, concentration should be placed on the relative closeness of the connection between the nature of the employment and the particular tort, not just whether the employee had done an authorized act, or used an improper mode to carry out an authorized act. Note that this test flowed out of the deficiency that the traditional test brought about. For the effects of express prohibition on the employee, see the cases of Canadian Pacific Railway Company and Lockhart per Lord Frankerton, Limpus and London General Omnibus per Williams J, and Morris and Martin per Diplock LJ. For protecting the master's property, in Poland and Parr, Banks LJ stated that, as a general rule, a servant has an implied authority in an emergency to endeavor to protect his master's property if he sees it in danger or has reasonable grounds for thinking that he sees it in danger, and an implied authority is as good as an express authority. For the position on procedural bar, in Brune and Morgan, Denning LJ said, the master is not liable when a servant does something on a frolic of his own. He is only liable when the servant is acting in the course of his employment. He takes the benefit of the work when it is carefully done, and he must take the liability of it when it is negligently done. If a servant is immune from an action at the suit of the injured party owing to some rule of law, nevertheless, the master is not thereby absolved. The master's liability is his own liability and remains on him notwithstanding the immunity of the servant. See also Boba and Ministry of Interior per Abaji J on procedural bar on the Republic. Before concluding on vicarious liability, let's look at the two defenses available to an employer. They are contributory negligence, as could be seen in Clifford and Challen and Sons, and voluntary non-fit injuria, as could be seen in Withers and Perry Chain. Here, Devlin LJ stated that there is no legal duty upon an employer to prevent an adult employee from doing work which he or she is willing to do. If there's a slight risk, it is for the employee to weigh it against the desirability or perhaps the necessity of employment. The relationship between employer and employee is not that of a schoolmaster and pupil. There is no obligation on an employer to offer alternative safe employment, though no doubt a considerate employer would always try to do so. Nor is there any obligation on an employer to dismiss an employee in such circumstances. It cannot be said that an employer is bound to dismiss an employee rather than allow her to run a small risk. The employee is free to decide for herself what risks she will run. Concluding, it is necessary to point out that in Ghana, under the Labour Act 2003 Act 651, Section 9 imposes a duty on employers in the following words: without prejudice to the provisions of this Act and any other enactment in a contract of employment or collective agreement, the duties of an employer include the duty to A. Provide work and appropriate raw materials, machinery, equipment, and tools. B. Pay the agreed remuneration at the time and place agreed on in the contract of employment or collective agreement, or by custom without a deduction except deduction permitted by law or agreed between the employer and the worker. C. Take practicable steps to ensure that the worker is free from risk of personal injury or damage to health during and in the course of the worker's employment or while lawfully on the employer's premises. D. Develop the human resources by way of training and retraining of the workers. E. Provide and ensure the operation of an adequate procedure for discipline of the workers. F. Furnish the worker with a copy of the worker's contract of employment. G. Keep open the channels of communication with the workers. And H. Protect the interests of the workers. This is the end of our 13th episode. Please do well to subscribe, like, write your comments, and help share. Thank you.